So hello everyone, welcome back to the channel, and today we are going to have our part 4 of the Companies Act, and in this part we are going to discuss 10 most important MCQs, right? So we have already covered our 3 parts of the Companies Act 2013, and in which in the each class we have already discussed 10 questions in the each class, right? So today again we are going to discuss that, and the approach would be same. You have to attempt each and every question on your own first, and you need to understand ki what the question is asking to you and what the provision, related provision is that, and then whatever provisions I'm going to discuss with you, you should try to remember those provisions and clauses. ठीक है everyone? चलो. So let's directly jump to the first question without delaying further. First question says, as per section 419 of the Companies Act 2013, the number of benches are notified by dash considering the number of cases to be heard, including the cases under IBC. So the question is saying to you कि the number of benches means the group of 2 or more judges when there is a case now. So the who decide as per 419 section of the Companies Act 2013, what will be the number of benches, the group of the judges who's going to decide that? State government, CAG, central government, none of the above, or both A and B. And let me check the chat section as well. Yeah, don't worry if you are wrong or right, because it is not going to matter. You need to remember each and every fact, right? Okay. So the answer would be central government here. So central government is going to decide what is going to be the number of benches, okay, considering the number of cases that needs to be heard by them, right? Okay. So yeah, you are correct, Nilesh here. Okay. So let's move to the second question, which says, which of the following is true? First statement says, as per section 196 of the Companies Act 2013, no reappointment of managing director, whole-time director or manager shall be made earlier than 1 year before the expiry of his term. So basically it wants to tell you that if some managing director, whole-time director has been appointed, right, and suppose his duration is 5 years, so you won't be able to reappoint them. Prior to this 1 year from the date of their expiry, from the date of their tenure expiry, right? So before this 1 year time, total time is 5 years. Before this 1 year time, they can't be reappointed. So between this period, they can be reappointed, but before that they can't be reappointed. This is what first statement is saying, so it is absolutely correct. Second statement says, appeal against orders of NCLT are made to NCL Appellate Tribunal, that is National Company Law Appellate Tribunal. So it is absolutely correct. Appeals against the NCLAT are made to High Court. No, it is not correct, because appeals against the NCLAT orders are made to Supreme Court. So statement 1 and 2 is correct, and option number B is correct. And let me check the chat section. Yes, most of you are correct here as well. That's very good. Chalo, let's move ahead with the third question. It says, as per section 177 subsection 2 of Companies Act 2013, the Audit Committee shall consist of minimum how many directors? So it is basically talking about the Audit Committee, and it is asking you about the section 177 subsection 2. So let's read it out in detail. Subsection 2 of section 177 says कि the Audit Committee shall consist of a minimum 3 directors, but you have other things as well. Therefore we are reading out full section, right? That is section 177 subsection 2. Minimum 3 directors you should have, with independent directors forming the majority. This is also important from the examination point of view. So minimum 3 directors should be there, with the independent directors should be forming the majority, right? Plus, provided that the majority of the members of the Audit Committee, including the chairperson of that committee, shall be a person who has the ability to read and understand the financial statements, that is your PL account, balance sheet, cash flow. So the Audit Committee members you can say can't be those members who has no ability to read this financial statements, right? So this also you need to remember. Now, so the answer would be 3 directors here, and your correct option is option number B. Let me check. Yes, most of you are correct again here. Okay, that's very nice. Chalo. Question number 4 says, as per section 154 of the Companies Act 2013, in case application is accepted, application of what application? DIN application. Basically 154 talks about the DIN application is accepted, the central government shall allot DIN within how many months from the receipt of the application from the director to be appointed DIN. ठीक है, to allot the DIN to them. So within how many months government has to basically inform the applicant, right, and allot the DIN within how many months of the receipt of the application from that person. 2 months, 5 months, 1 month? Yes, answer is 1 month. So generally what happens na ki when if you want to be a director in a company, suppose, ठीक है, and you have filed an application to the government, central government, that is through the MCA, Ministry of Corporate Affairs. Generally, or I can say usually, what happens, they allot you DIN within 1 week or 2 weeks, but the prescribed time limit in the Companies Act is 1 month. But usually what happens, within 1 month or within 1 week or 2 weeks, they are going to allot you DIN as well. Okay? But from the Companies Act point of view, the time limit is given, maximum time limit is given to the central government as 1 month. Okay? Now let's talk about the next question, that is question number 5. As per section 173 of the Companies Act 2013, every company shall hold the first meeting of board of directors within how many days from the date of incorporation. So if the company is newly incorporated, what is the provision regarding first board of directors meeting, first BOD meeting? In how many days or months they must attend, or they must convene the board meeting? So the answer would be 30 days, or you can say within 1 month. So the option number B would be correct. And let me check the chat section. Yes, again most of you are correct, and even if you are not, you have to remember these facts. Okay? Okay. Now let's talk about question number 6. It says, which section of Companies Act 2013 deals with the Audit Committee? Now questions like these, I can say there are less chances ki questions directly asking the section number. There are less chances that question would be there. But yes, only less chances are there. I'm not saying ki there are no chances. It might happen ki one question could be asked from the section number. Ki you would be asked the you would be given the topic and you have to find out the section number, the related section number. It might happen, right? So therefore I have only included one question like that, in which you have to tell me what is the section number that deals with the Audit Committee. Section 153 no, section 177 yes. So option number B would be the correct answer here. And let me check. Yes, again most of you are correct, and that is very good. So let's read out the other sections as well for which they are related to. Section 153 talks about application for the allotment of DIN, that is Director Identification Number. Section 203 talks about appointment of key managerial position. Again, this section is also important. This can also be directly asked. Okay? 410 talks about constitution of the National Company Law Appellate Tribunal. Okay? So after 400, you have this Company Law Tribunal and Company Law Appellate Tribunal sections. Okay? Okay. Now let's talk about question number 7. It says, as per section 423 of the Companies Act 2013, any person aggrieved by any order of the appellate tribunal. So if a person, if suppose you are not satisfied with the order of the appellate tribunal, so you are going to file your appeal against the order of the appellate tribunal to the Supreme Court. But how many days of window is given to you from the date of receipt of the order in which you can apply, basically in which you can appeal to the Supreme Government? How many days of window is given to you against the order of the National Company Law Appellate Tribunal? So the answer would be 60 days. So option number C would be correct. And let me check the chat section. So here you might be confused between 45 and 60, and I can really understand that. Why? See, here is the catch here. See, 45 is the case when you have to appeal against NCLT to NCLAT. Now I am asking you, you have to appeal against NCLAT to the Supreme Court. So this window is 60 days, but this window is 45 days. So I can really understand this. Don't worry. Okay. Don't worry if my video is stuck. Okay. Don't worry. I'm going to off my okay. Just wait for a minute. Yeah. Okay. Everything is fine now. Chalo. So understood ki why, when there will be a case of 45 and when there will be a case of 60, right? So when you are appealing against the order of NCLT, okay, when you are appealing against the order of NCLT, then the time period is given to you as 45 days. But right now the question is asking to you, you have to appeal against the order of appellate tribunal to the Supreme Court. So the time given to you is 60 days. Okay? Okay, chalo. Now let's move to the 8th question that says, as per section 204 of the Companies Act 2013, every public company having a turnover of how many crores of rupees or more shall conduct a secretarial audit. So for which type of companies it is necessary to conduct this secretarial audit as per section 204. So there are various conditions. Let's look at this section 204, then we will understand this question. Okay? So section 204 of the Companies Act says ki every public company having a turnover of 250 crores or more shall conduct this secretarial audit, or every public company having a paid up share capital of 50 crores. So you have to remember these numbers. Okay? Turnover of more than 250 crores and paid up share capital of 50 crores or more, and outstanding loans or borrowing from the banks of 100 crore rupees or more. So you need to remember these three figures. Which three figures? 50 crores, 100 crores and 250 crores. 50 crore is for paid up share capital, 100 crore is for loan or borrowings, 250 crore is for turnover. So you need to remember these figures. Okay? So the question is saying about the turnover only na. So you need to take 250 crore, that is option number C. But remember, question could be asked from you from the other areas as well, like from the outstanding loan, like from the paid up share capital. So that's why we are discussing all the this complete section of 204. Okay? Or related concept regarding this 204. Now let's talk about question number 9th. It says ABC Limited wants to appoint a resident director to its board. Okay, choose the requirement as per the provision of the Companies Act 2013 in respect of the resident director. What are the requirements that needs to be fulfilled as per the Companies Act 2013 to appoint a resident director? To appoint a resident, please remember, resident and citizen are two different concepts. How? Okay, let me tell you how this as well. So you have heard the word of NRI or not? So NRI, that is non-resident Indian, are the citizen of India, but they are residing in a foreign country. So that is the difference between resident and the citizen. So it is asking you, question is asking you to appoint the resident director, even if he is a foreigner, he or she is a foreigner. But you need to see if he or she is a resident director or not. So what conditions must be fulfilled? Resident director must be citizen of India. Stay of resident director in India shall not be less than 182 days during the financial year. So it is absolutely correct. So even if it is not the citizen of India na, then also it can be appointed as the resident director, because we are not talking about Indian citizen director, we are talking about a resident director. So stay of the director in India shall not be less than 182 days. Okay? So the correct option would be option number B, I guess. Yes, it is option number B. And most of you are incorrect here, but don't worry. Yeah, it was a tricky question, obviously, because here you might be confused between citizen and the resident. Therefore, I have discussed with you the difference between these two. Okay? So the answer would be option number B, not A and B, right? Option would be option number B. Chalo. Let's move ahead with question number 10th, which says Mr. Singhania is a director in a company A and Mr. Kishan. See, now look at the question very carefully. Mr. Singhania is a director in a company A and Mr. Kishan, who is relative of Mr. Singhania now, okay, is a partner in the company B. Now this Mr. Singhania is a relative, okay, of Mr. Kishan. Now can the company A provide loan to company B? So the answer would be no. Clearly it would be no. Okay. No, Dhaval, it is not necessary, na? It is not necessary. If you are saying, sir, if someone is resident, then would be a citizen as well, then it is not necessary. I have given you the example of NRI, na? Similar is the case for the foreigner as well. If someone is resident in India, so it is not necessary कि he is a citizen of India. ठीक है? Okay, clear? Okay, chalo. So the answer would be clearly no here in this 10th question. ठीक है? Chalo. And why? Let's read out the section in detail. Company shall not advance any loan or give guarantee or security for any loan taken by any director to of any company or holding company or relative or partner of a director, any other firm in which this relative is a director. So in this case, what is going to happen here? See, Mr. Singhania is the director of company A, but Mr. Kishan, who is the relative of Mr. Singhania, is the partner of company B. So he can't, this company A can't give loan to company B, or he can't give loan to Mr. Kishan as well. So the answer would be no here. Okay? Now let's do the last question that says, as per section 153, we have to identify which statements are correct here. As per section 153 of Companies Act 2013, form DIR 3 shall be signed. So 153 is about the DIR, right? DIR 3 shall be signed and submitted electronically by the applicant using his or her own digital signature certificate. It is absolutely correct. So if you want to be appointed as the director now, what you need to do? You need to file DIR 3, okay? And you need to sign this document with your digital signatures. Okay? Whenever you file any form to the ROC or to the MCA, na, you need to sign it with the digital signature, not the physical signature. Okay? And second statement says, so first statement is correct. Second statement says, the above form shall be verified digitally by a company secretary in full-time employment of the company, or by MD or director or CEO or CFO in the company in which you are applying to be the director of the company. See, in this case, you are applying for the DIN number or to be appointed as the director for the existing company, okay? And it is saying, if it is the case, then that form shall be signed by the company secretary in full-time employment with the company, or with the CEO, or the form or the sign of CFO will be required, or the sign of managing director will be required. So it is absolutely, this is the homework question why I am giving you the answer here. I don't have to give you the answer here, na? Okay, chalo koi baat nahi, मैंने बता दिया, कोई बात नहीं. So second would be the second is also correct here. And third, you have to identify yourself. Okay? I didn't see this homework mark here. So this was the homework question. So you have to answer with this question. Na? Okay. So you have to answer with this question in the comment section. Okay? Third statement I am reading out for you, but I am not going to tell you if this is correct or not. First two statements are correct. So third statement says, National Company Law Appellate Tribunal was constituted under section 410 of the Companies Act 2013 for hearing appeals against the orders of High Court. Chalo, you have to tell me this statement is correct or not. First two statements are correct, and you need to give me the answer ki what is the option here which is correct in the chat section or in the comment section. Okay? Chalo. Now that's all for today's class. We are going to again meet in the tomorrow's class at the 4 PM, and then we are going to look at 10 more important questions. ठीक है? चलो फिर तब तक के लिए टाटा बाय बाय, टेक केयर एवरीवन.